once he goes to get married. He's not gonna.
Another break.
I like to like, I go to concerts and silence and
It's always good to take a break in the first 20 minutes of the class. But unfortunately, we've got a 2-hour class. So I say we still find time to squeeze in a second break. What do you say?
please.
Yeah. But now, I'm awkward as can be up here as usual, but I'm far more awkward than usual because I gotta hold this microphone. So if I'm too loud, too quiet, please let me know, and I can either lose the mic and just talk like this, or I can put the mic a little closer to my mouth and talk like that, whatever works best for you.
Microphone.
Mic, use the mic. This way,
Well, yeah,
that way.
whichever you prefer.
Can I do one of those drop the mic things? Because I want to talk to you about constitutions. I know that our syllabus came out just at the last minute, and our textbook, of course, we're still waiting on. So I don't expect any of you have read hundreds or thousands of pages on the topic. But perhaps some of you managed to read these 7 pages that I highlighted. Anybody get a chance to read the 7 pages? All right. Yes, I'm seeing just better hand, so that's great. So you know where I'm coming from today. Why are there state constitutions? Why bother with the state constitution? Who will talk to me about why there are state constitutions? And in our textbook, perhaps the first issue we looked at was history. History was an explanation as to why these constitutions exist. Indeed, if we go back in history, there were 13 colonies before there was a federation when we are talking about the United States of America. Anyone unfamiliar with that concept? Nope. Okay. Now, these 13 colonies, almost without fail, had state constitutions. So as these colonies came together to form a more perfect union, I coined that phrase myself, you like that? Yeah. In order to form a more perfect union, they came together, and they came together already having state constitutions in place. So one of the reasons why state constitutions exist is because state constitutions existed before we had our federal constitution. Now, thank you, historians, for pointing out that topic. Perhaps we could call the historian that told us that Captain Obvious. Thank you, Captain Obvious, for pointing that out. But Captain Obvious, that does not inform us as to why state constitutions persist today. Surely that was the answer in 1776. But what about the here and now? Why bother with a state constitution? Now, as we think about that, one of the things we have to consider is what is a state constitution anyway? Is the state constitution an amendment to the federal constitution? For example, in your 1L class, you took a class on contracts. Anyone here not study contracts in law school? Okay, good. Everyone studied contracts. Is a state constitution an amendment to the federal constitution? Is that how it works? And I would say, no, that's a poor analogy. The reason that's a poor analogy is because of the supremacy clause in our federal constitution. Our federal constitution does not, NOT, does not say, here's your constitution, follow it, unless your state constitution says otherwise. Our federal constitution contains no such clause. To the contrary, the supremacy clause states that all state laws, even state constitutions notwithstanding, the federal constitution, therefore, is the law of the land. Oh, just coined another phrase. I'm good with these new phrases. Yeah, never heard that one before, right? Federal constitution is the law of the land. You better write that down. So, federal constitution, therefore, reigns supreme when it comes to state constitutions. So, I've beaten the question to death here. What is the answer? Why are there state constitutions? What good do they do us? Well, another perspective taken in the text was the perspective of utility. State constitutions provide us a source of organic law when it comes to state government. After all, our states are guaranteed by the federal constitution a Republican form of government, meaning republic, I'm not talking about politics, Republican versus Democrat, not talking about which party prevails in a particular state. I'm talking about the type of government, a republic. We're guaranteed that in our federal constitution. And it is our state constitutions that provide the utility, that spell out that there is a state judiciary, that there is a state executive, that there is a state legislature. And indeed, state legislatures, county legislatures, city legislatures are all sources of lawmaking. So we have an organic source of law in our state constitution. But I dare say that answer still begs the question. After all, couldn't the Congress spell out in a federal statute how state legislatures are to run? Couldn't the Congress spell out in a federal statute how the state executive branch runs? All these questions based on the supremacy clause and the federal guarantee of a republic together means that Congress indeed could pass laws to serve the same purpose that we see in state constitutions. So, as I point out in the text, all these descriptors do not ultimately answer the question as to why we have state constitutions that persist in the modern age. And from that conclusion, I put forth a hypothesis. And this is our first lecture together. That's something I like to do. I like to put forth a hypothesis. I like to discuss with you whether my hypothesis is correct. I like to hear your thoughts, your criticisms, your perspectives on my hypothesis. You see, from my perspective, and as I've already admitted, I'm not a professor. I just play one on Tuesday nights. From my perspective, it's not my job to indoctrinate. It's my job to educate. From my perspective, I put forth hypotheses. And in so doing, that puts forth for you the black letter law that you're attempting to learn. But, Lord willing, law school can be more than just rote memorization of black letter law. Lord willing, law school can be a place where you can take black letter law and make it a tool in your fight for justice. Ultimately, if you decide to become an attorney, you might find yourself having to interpret the law and advise clients. You might find yourself litigating issues in front of a tribunal or court. You might find yourself having to apply the black letter law that you're learning in law school. So if you don't mind me doing it, why not make that a skill that you learn in law school? So I try to take a very practical approach. So what I've done is I've put forth a hypothesis, and I've done it in my textbook. And you'll forgive me being vain enough to assign my own textbook for this class. But I've been teaching this class since 2015. When I started in 2015, I was warned there's only one textbook out there. And it is an excellent textbook, I was told in 2015. But it's starting to show its age, I was told in 2015, because it hadn't been updated since 2013. Now, 2013 was a long time ago, but yet no one's updated that excellent textbook yet. So if you were to take another law school class on Florida constitutional law, you would probably be studying from that textbook. And I am not attempting to criticize it. To the contrary, it's an excellent textbook. The only thing I point out is that 2013 was not yesterday. Anybody carrying around a cell phone from 2013, how's it doing? I see a lot of laptops here. Most of them were made in 2013, is that right? My car dates back to 2013. She's running strong, and I hope she continues to run strong, but she's not brand new, is she? Has anyone seen anything on the news talking about constitutional law issues from 2013 to the present? Has that been a newsworthy topic? Anything happened in the constitutional world from 2013? A lot has happened. A lot has happened. So I've taken it upon myself to write you a new textbook. I hope I did a good job. And in that textbook, I put forth several hypotheses, including the one I'm about to talk about now. And what I want to hear is from you. I want to hear what you think of my hypotheses. Again, I'm not here to indoctrinate. I'm here to educate. If you think I'm wrong, feel free to say, McKinley, you are wrong. I might even agree with you by the end of the day. My hypothesis as to state constitutions is this, that although the historian accurately tells us why they existed and were created in the first place, and although the functional form of constitutions certainly serve an important purpose, the reason subnational constitutions persist today is because of a basic human need. This is my hypothesis. A basic human need called subsidiarity. Subsidiarity, I believe, inspired these founding fathers to create a republic where power and accountability was not in one central figure, but instead was dispersed. Dispersed between and among branches of government, dispersed between and among a federal government and state governments. Subsidiarity is this human need that we see in so many of the encyclicals written by the popes in our Catholic Church. And on this slide, I quote from St. Pope John Paul II. It's hard to do better than St. Pope John Paul II. And in his 1991 encyclical, Centenimus Annus, he defines subsidiarity in this way. A community of a higher order should not interfere in the internal life of a community of a lower order, depriving the latter of its functions, but rather should support it and help to coordinate its activity with the activities of the rest of society, always with a view toward the common good. This is how Pope St. John Paul II described subsidiarity, and I can't possibly draft a better definition for that. I can draft a shorter definition, however. Insufficient, but shorter, and if I dare say so, kind of catchy. You've seen me coin quite a few phrases so far. Stated somewhat differently, subsidiarity means that local problems sometimes require local solutions. Local problems sometimes require local solutions. Now that's a great understatement, and it leaves out a lot of details that Pope John Paul II's encyclical would never dare to leave out. But it is a quick way to remember what we talk about when we talk about subsidiarity. Now, localism is certainly in vogue in many areas of society today. Are there any foodies? Foodies in the audience? This may come as no surprise. I like to eat. Anyone else like to eat? Yeah. And what's the trend in foodies today? Do we all want to eat the same pasteurized and processed cheese that came out of the same one factory and then is distributed everywhere in the world? Is that what the foodie is after today? No. Who's a foodie here? What foodie can talk to me? What's a foodie looking for when a foodie goes out? Oh, tacos. I love tacos. They made me teach on Tuesdays on Taco Tuesday. I love tacos. You like tacos? What do you want to see in your tacos?
Just steak, cilantro, and onions.
Steak, cilantro, onion.
Oh, wait, and a splash of lime.
Oh, yeah.
Oh, wait, a shot
Lime.
of tequila and a Corona.
And now we're talking. But foodies are looking for the latest food truck, right? They're looking for the latest restaurant. And hey, I love Taco Bell as much as the next guy, gal, or person. But isn't it fun to find that local chain that does tacos in just that unique way? Maybe with some fresh local ingredients. Who here loves to have some fresh local ingredients on the menu? Right? Maybe you don't like to eat, maybe you like to drink. I'm Catholic, we're allowed to drink. It's a nice thing. I may have had a beer in my lifetime. I'm Irish. Did you know that there are breweries, local breweries, craft beer, quite in vogue nowadays, isn't it? People love craft beer, nice, unique taste that they'll locally. It's been said that, especially in tourist areas, when a tourist goes to a restaurant, they don't want Bud Light, they want to try the local brewery. Localism is certainly on people's minds when it comes to food, when it comes to drink. How about when it comes to government? Are there times when local problems warrant local solutions? Have you seen such a thing? Allow me to give it a try to come up with an example where everyone might agree that it's a local problem and it requires a local solution. Let me try to set forth, there's got to be a marker around here somewhere, here we go. Let me try to set forth a spectrum, a line, a scale, if you will. And let me start over here. Maybe there's no problem that's purely local. Maybe there's no problem that's purely federal. But let me try to set the table, if you will. Let me try to put some spaces on the spectrum so we can decide where things go. Let me try to find as close as we can to a truly local problem. Anyone ever drive and hit a pothole? Anyone ever hit a pothole? A pothole is a real problem, okay? It's a real problem. Imagine on your street, some of your brothers and sisters are living paycheck to paycheck. And nowadays, just like in the past, and probably just like in the future, there are many of our fellow Americans that live paycheck to paycheck. Imagine your neighbor living paycheck to paycheck hits that pothole, damages the car, has to have that car to get to work, has to go to work to put food on the table, and now has to choose between fixing the car and putting food on the table because of that unexpected expense caused by the pothole. So let's not belittle the problem of the pothole. Let's not underestimate the problem of the pothole. For some of us, that can be a real problem, right? I've got students in the audience. Perhaps some of you are living paycheck to paycheck right now, right? Perhaps when I say foodie, you say ramen noodle. I don't know. Yeah. That happens. So answer me this, tell me this, say that you want to solve the problem. The problem is a pothole, okay? Let's look at different ways government structures could be set up. And as I consider those structures, I want you to ask yourself this. Put yourself in the shoes of the problem solver. You yourself are going to solve this pothole problem. You've got to reach, talk to, and persuade the decision maker. Understood your mission? Your mission is understood. Okay. All potholes, when they're filled and how they're filled, are decided by the United Nations. Option A. A globalist approach, if you will. Because after all, the whole world should be full of potholes. Why shouldn't a worldwide organization be in charge of what potholes are filled and how and when? So option A, all you've got to do is appear before the United Nations and convince the nations of the world to fix your pothole. Option B, the White House. All you got to do is meet with the president and convince the president of the United States to fix your pothole. Option C, the Congress. We all have a senator, right? Have you met your senator? I have not. Can you name your senator? Do you know the location of your senator's office? Is your senator even in your senator's office, or is it the senator in Washington, D.C.? Option C, you gotta meet with your senator. Option D, all you gotta do is talk to Florida's governor. Yeah, that's easy, right? We're standing in Orlando right now. What is that, a 5.5 hour drive? Come on, we can be there before midnight. Let's go. And when you ring the bell in Tallahassee, ring the bell of the governor's mansion, surely the governor will answer the door, right? Option D, the governor. Option E, Joey. Joey lives 3 doors down from you. Joey's on your city council. You see Joey when you're shopping at the supermarket. You rub elbows with Joey just inadvertently. You see Joey in the pew at church. You see Joey as you're driving around town. So you, pothole problem solver, where do you feel? Under which of these A, B, C, D, E government structures do you feel you'll be more efficient, more effective, you'll more easily get the job done, you'll solve the pothole problem? Who will take an opinion on this?
Go with Joey.
You're going with Joey, you're going with E. Why? Why is E the more efficient solution there?
Joey works directly for my city or town, and the funding's gonna come from the town, and they'll go to public works, and I don't know, hey, go to Avenue B and go fix that pothole before someone else moves up their tire.
I agree, you'll have access. So one concern, when it comes to subsidiarity, when it comes to subnational governments, whether state governments, county governments, city governments, one concern is access, is it not? Who needs access to this particular government entity? When we decide what level of government should be the decision maker, when we apply the principle of subsidiarity, one concern is access, is it not? Thank you, you've raised a great point. What's another reason you might pick E? I tried to set this up so E was the obvious answer. Was anybody leaning toward A? You wanted the United Nations in charge of your local potholes? No, okay. Yes, what's another reason you might pick?
Well, Joey's part of the community, so he'll have stake in the pothole being fixed.
Oh, stake. That's S-T-E-A-K?
That's my favorite kind.
Stake. However you want to spell stake, I'm gonna go with S-T-A-K-E for this particular usage. But yes, I see what you're saying there. A stakeholder. The decision makers among the stakeholders. Maybe Joey lives right on your street, maybe Joey hit the pothole. Stakeholder. What's another reason when it comes to the pothole problem? Subsidiarity might dictate local government is the correct solution. What else is involved here? What about expertise? As you appear before the UN, you'll meet various individuals from various nations, of various continents, of various languages throughout the world. Are they familiar with Main Street USA? Compare that to Joey, who lives 2 doors down from you on Main Street USA. Is Joey familiar with Main Street USA? So what about expertise? Compare this, what I hope is clearly a local problem of the pothole. Compare that to a problem which perhaps is equally clear is not a local problem. Wasn't sure what to pick. Over here, you've got the pothole. I put that on the spectrum, very close to certainly a local problem. What can I pick on the other end of the spectrum? What can I pick as almost certainly not a local problem? How about this hypothesis? How about war? War. What if the Orange County Board of County Commissioners has a meeting and they're fed up? They're fed up with Canada. They're fed up with Canada because when they drink the Molson Light, which tastes like water, they're fed up with Canada because Canada's not importing much oranges from Orange County. They're fed up with Canada in Orange County because all the great ice hockey players are being persuaded to move out of Orange County, Florida, and to Canada. So Orange County Board of County Commissioners take a vote and they reach the obvious solution. They declare war upon Canada. Is war a good problem that should be solved on the county level? Should counties go to war? Cities? States? Well, the state of Florida is equally upset with the nation of Canada. Should the state of Florida be allowed to declare? Okay, so let's pick war. War. Why is war making? Why is the decision to go to war or not go to war closer to a federal solution and farther from a local solution? Is it due to access? Well, that Molson Light that tastes like water. In Orange County, they're affected by that too, right? So that's not the answer. Is it stakeholders? Ladies and gentlemen, if you've been blessed enough to meet any individual who has served our country, you know that that's a very local effect. That person has a spouse, that person has children, that person has family, who loves them and cares for them, and doesn't want to see them go overseas and risk their lives, wants them to come home safely, right? So that's not it. What about expertise? Again, if If you've met the soldier, if you've met the sailor, if you've met the airman, if you've met the guardsman, you know what expertise they have. So these three, access, stake, and expertise, that's not the reason why we laugh when I suggest that it should be up to the Orange County Board of County Commissioners as to whether or not we go to war with Canada. And for the Canadians among us, I apologize. I had to pick a nation. I picked Canada. It's mostly because of my dislike of Molson Ice. Have you tried Molson Ice? I swear it tastes like water. But I apologize to all Canadians and to all Molson Ice drinkers. I certainly love and respect Canadians. So just had to pick a nation for Orange County to be upset with. So. But why is it so obvious that war is closer to a federal problem despite subsidiarity instead? Yes.
Because whatever decision that Florida, let's say a county level or a state level makes, is going to impact other nations.
Yes.
Other states.
Yes.
And then, Florida goes to war with Canada, then it drags force back on the states to come involved.
Oh, tell me that last part again. I was writing down impact. I don't want to miss a word.
No, I said Florida or Orange County goes to war with Canada, then there's now force back on the states involved because of the decision made at the local level by county or the state level.
Yes. And do I summarize that there by saying it's a question of impacts? It's a question of impacts. Maybe the state of Florida wants to go to war with Canada, but the state of Georgia does not. The state of Alabama would like to stay neutral. I don't know. We're making these things up. But certainly Florida, Georgia, and Alabama are all impacted by Florida's declaration of war upon Canada. Impacts. So the impacts tell us to move that question farther up the line, if you want to call that up, toward a federal solution instead of a local one. I say expertise, although I dismissed it earlier, might also be part of it. What about resources? And again, I apologize to my Canadian friends for having picked their nation as my hypothesis. But what if you truly want to win the war against Canada? Should you just use the Florida National Guard, or should you have even more troops involved in that? Resources, I would suggest, are one of the considerations that move the question toward the federal. So it's certainly true that there are many issues that we face. And we've got to factor in where they should fall when it comes to the question of local versus state problem. Let me ask you about some others. What about crimes? Where would you put the criminal law? Is that a local problem, or is it a federal one? For 23 years now, I've been practicing many areas of the law, but never criminal. I don't even dabble in the criminal law. But I've met many a law student, perhaps you, who studies seriously the criminal law and intends to practice it. Where's my criminal law practitioners, future criminal law? Oh, thank you. Thank you for identifying yourself. Where do I put the criminal law? To decide whether something is criminal or not criminal. Is this a local problem to be solved at the local level? Is this a federal problem to be solved at the federal level? Where do I put it? Yeah. There's no wrong answer here, so don't stress.
It would depend on the level of the crime.
I love that. Yes, you started with it depends. And y'all remember, you're in a constitutional law class. That's a great way to start any constitutional law question, right? It depends, right? Right? Good start. I like it. So it depends. It depends on what? Depends on balancing some factors. And again, we're in a constitutional law class, right? So we're answering a common law question. Always depends, right? And there's always factors to be balanced. Am I right or wrong? Yeah. So how would you balance some of these factors that we've identified? So far, we've identified 5. We've identified access, stakeholders, expertise, impacts, resources. Would you like to pick a crime or shall I pick a crime?
Murder.
Murder. You're ready to kill me. I put you on the spot at day one, I can't blame you. Murder, you pick murder. Murder is a problem. Anyone disagree? Okay, good, we're on the same page so far. Murder is a problem. Access. Access to what? How about the witnesses? How about the evidence, right? Stakeholders, the families, the victims, the community, right? Expertise. Impacts resources. Nowadays, lawyers talk about the Csi Effect. Some juries don't want to just hear the eyewitness testimony. They're expecting, because of TV programs like CSI, to see some DNA. They're expecting to see some blood samples. They're expecting to see some forensics. These things are expensive to do, right? So whether or not something is a crime, where do we put it on the scale? Let me pick another crime, if you don't mind. Marijuana, pot, Mary Jane, duties, the wacky weed, puff the magic dragon. Anybody got another slang term I looked up? Oh, yes, yes, there you go. Yeah. All right, so suspect number one and suspect number two pass the duty to the left-hand side. And they do so in Orange County, Florida. Somebody's going to jail. What if they do that in Colorado? In Colorado, the stuff's legal, right? For recreational purposes, right? So the same doobie, the same weed, the same marijuana, the same Mary Jane, the same puff the magic dragon is perfectly legal in one state. It gives you a criminal record in another. That's the current state of the law, is it not? So when it comes to answering criminal law questions, how do we answer those? Do we answer them on the federal level today? Do we answer them on the state level? Do we answer them on the local level? Are there communities today, cities, where if you're arrested with a sufficiently small, as spelled out in their ordinances, amount of marijuana, that you get a civil citation instead of a criminal record? Yes. Is that something that should be decided on the local level, not the federal? What about torts? Anybody here study torts? What are torts? Torts are malpractice, right? Torts are automobiles that collide. Torts are folks that slip and fall. Torts are invited and uninvited licensees who are injured. Torts are negligence, duty, breach, causation, injury. When you studied your torts class, did they bother to tell you that the common law you were studying may not be so common? That every state on a state-by-state basis has, like Florida does, Chapter 768 has statutes spelling out what the cause of action is for a given tort, what the requirements are for proving that tort. Is that something that should be done on a federal level or state level? On the state level, sometimes we hear talk of tort reform. What are individuals talking about when they talk about tort reform? They're talking about protecting the tortfeasor, they're talking about protecting the insurance company's wallet, they're talking about limiting recovery, they're talking about making insurance premiums lower because recoveries are lower so that all of us can afford these insurance premiums. They're talking about limiting attorney fees. And as tort reform travels from state to state, what is one of the obstacles tort reform always faces? The state constitution. Rights such as access to courts, rights such as we find embodied in state constitutions that either allow or disallow the state legislature to make amendments, the kinds of amendments to these tort laws that you might refer to as tort reform. Should tort law be federalized? Should Congress step in? What are the factors that we must consider? Here's some of them. What about insurance itself? Can you buy insurance across borders? Usually not. Every state regulates the sale of insurance. Instead of preemption, federal insurance law contains a topic referred to as reverse preemption. Under reverse preemption, most forms of insurance, and I'm not talking about ERISA at the moment, but I'm talking about car insurance, health insurance, homeowners insurance, officers and directors insurance, professional malpractice insurance, various types of insurance, are governed by this concept of reverse preemption, where federal law says that federal law does not prevail, because federal law says that state law preempts federal law. Is that good or bad? Do you like the idea that a state's insurance commissioner can step in and say, sure, it's lucrative to sell health insurance here in Florida, but in order for you to do that, you've got to sell a minimum number of homeowner insurance here in Florida, even though the next hurricane is just moments away, my fellow Floridians. You put on a 30-year roof, you're an optimist. You will encounter at least 15 hurricanes during those 30 years, will you not? So I'm raising issues, but am I raising issues without solutions? The issues I'm raising are issues of subsidiarity. But what is the solution to subsidiarity? Subsidiarity as a concept rejects the notion that all problem-solving power should be vested only with the highest sovereign or federal authority. To the extreme, imagine communism. Imagine a dictatorship. Imagine a situation of a true king, of a monarch with absolute power. This individual would control anything and everything. Subsidiarity rejects the notion that all problem-solving power should be vested only with an absolute monarch. Instead, subsidiarity respects the proper role of problem-solving by states, by counties, by cities, and not just there. When appropriate, subsidiarity respects the problem-solving power of non-governmental organizations, private industry, religious institutions, temples, churches, the church, corporations, charities, even families. Can we think of a problem best solved by families, by the family unit? What about the problem of where we live? How many among us have chosen where we live? What if instead the government told us where we live? God forbid. But with that said, can an argument be made for that? What if hypothetically there were global warming? What if hypothetically living on the shore was not helping the situation? Should the federal government be able to say all those who live on the beach or have a beach house are now no longer property owners? We're confiscating all that land. It's affecting global warming too much, and it's costing too much in insurance premiums when those inevitable hurricanes or tsunamis or windstorms come. All coastal property owners are now no longer property owners. What would the concept of subsidiarity say about that? What about on the flip side? What if you're in Monroe County, Florida? You're in the Keys. Oh, would that be nice right now? Instead of sitting here listening to me ramble on and on, you're in the Florida Keys. The sun is shining. Maybe you're wasting away again in Margaritaville. You're looking for your lost shaker of salt. Some people say that there's, I'm sorry, I'm lost in my Keys analogy, aren't I? But what if you're in Monroe County and a particular road just keeps getting washed out again and again and again? Who knows why? Maybe it's because seas are rising. I don't know. and it's gonna cost you 14 million to raise up that road so it doesn't get washed out. There's just one problem. That road connects two houses to the mainland. 14 million will cost Monroe County to raise that road for the benefit of two houses. How does that fit in? Stakeholders, they certainly would like to have those two homes, those two families, those two residences would like to have a reliable road, right? What about the impact of the 14 million lost in tax revenue to benefit two houses? Does that, in your opinion, move the scale so that it's no longer a local solution and it should be closer to a federal one? These are the kinds of questions we have to answer. And are they simply unanswered questions? Is that all I've got for you in this class? Questions? Hey, McKinley, got any answers? I do. And I will give them to you after this 10-minute break. I like to end with a cliffhanger. Another one of my flaws. So let's, it's 6:45, am I reading that right? Okay, so we're right about at the half of the class, so let's take a 10-minute break. I'll see you back. And when I see you back, I'm gonna answer this question. How does the American Republic, how does the US of A answer these particular questions of subsidiarity? And spoiler alert, federalism. Federalism. See you in 10. Yeah, I got that.
Yeah, okay, so question, okay. So regarding, like, I think we have a paper, and I'm out February 1st.
Well, you can hand it in early.
Okay, well, when will I get, I'll have it before?
Yeah, I
I
tell you
didn't
what,
know.
I'll have it for the day. I'll bring it to you.
Okay.
Right.
So then so you'll give it to us next week, and then I can turn it in before.
Oh, of course.
Okay, and then,
Early.
and
Late.
then whenever I miss for that stuff, you post stuff from your IG for sure.
Not only do you post slides, but I got the YouTube, it's working.
Oh, that's right, so I can watch.
I think it is working.
Okay,
So
cool.
you'll be able to watch the video. Yeah, stare at my ugly mug as long as you want.
Thank you.
Hello. Oh, hey, nice to meet you. Yeah. I haven't handed on the second. I don't know, it's all a matter of respect. But it's all on video, so, yeah. Sure.
She's very professional. Okay, so what you got? I'm the secret center. Okay. Okay, you're like a 99. I need it. It's not
Is it?
I don't know, I think it's only for like. No, it was so.
It's a lot. Let's make
So I just had it.
I want to know.
Yeah, heads up.
I used to sit in front row center, but I found the class. I have to have consistency. So when I always really sit chats or that, and I find that, except that's what I'm. Like I bring someone center where there's just more person in front of me, and I can't grab and I'm supposed to do the words because in the back, forget it. So in my first whole year, I made mistakes.
The dog really didn't know. Oh my God, that's why I know myself. I know she's trying to wait for me. Oh.
I don't know.
Oh, myself is sitting right here.
Oh, she did.
Oh, higher.
So. I don't know.
Voice is very peaceful and very
It's not a lullaby, it's not yoga.
You can do the same thing.
Yeah. So like, I need a dog. I need some more pressure. At this time, I
Professor.
Was amazing.
Send the sheet.
Yeah, I always do that after the prayer. Sometimes I remember right after the prayer, sometimes I remember well after the prayer, but I always do that after the prayer. For anybody who doesn't want to hear me pray, they can show up a few minutes later.
How would we know that you prayed though? I didn't hear the gossip until like,
Oh, really? I always figure out some sort of outcast that we're talking about. No? Okay.
I found out too late, but anyway, whatever, we got to experience it, and it's not a bad thing.
There you go. And just keep coming. So bear with me.
But when you said you do it at the beginning of every class,
Every class.
now there's two different kinds of beginning of every class, right?
Yeah.
There's the first class of the semester, and
Right.
there's the beginning of every
I mean,
single
every
third
Tuesday at 5:45 is what I mean.
Yeah, but that means that we gotta pass it out to go to mass or something.
Oh,
No, you're still getting that. This is
I don't know what's so-
He was like, yeah, we can, don't tell him that. What are you doing? Minus .05.
Give it a minus for that.
Now, did you really do that? No, I'll pray for him later, like.
Okay, here we go. He didn't mean it. He didn't mean it.
Well, Professor, you went to mass. Yeah, exactly.
Yeah, say
I went to
so, like
mass on Christmas.
Christmas is a good time to go. Yeah, Easter another
I
good
always do
time.
midnight mass.
Oh, you do midnight mass? I haven't done midnight mass in years.
Yeah, are they the only-
Don't admit that.
Well, I go to mass, but not midnight mass. Well, midnight mass is hard. I got those little kids. You saw them up there. I'm trying to bring them to
You're in the
midnight
line.
mass.
Oh, no. Someone told me that. It was so funny. One of the clients, when I was doing this, said that in Europe, like, how they did.
It's always midnight.
And I didn't know You know, the baby's like, when they're sleeping.
I know.
Mariah,
It's
they're
different.
I don't even really.
I don't know, if you said, see, Americans are like, so,
I don't like
but in
that.
Europe, like, you know, if you slip your finger in the eye, like, you don't give it to a pastor. You know, you slip your fingers, you just put it on my gums.
Okay.
Something.
And that helps with the teeth.
If you just fall asleep.
Yeah.
I'm like, oh.
Yeah. It's not the end of the world.
No.
Yeah, yeah, that's a good example, like different attitudes, you know? Yeah.
He told me that.
That's the good thing about that.
But that's not correct.
Yeah. Well, Patrick's 10, Madeline's 6. Midnight's not their thing.
No, I think it's on one day.
Oh, yeah.
And you're on a morning.
I'm not. I'm a night person, but still.
Yes, it is.
Welcome back, and there's some of us are back, some of us aren't, that's okay. People come back little by little. Over the cafeteria, there's a line I noticed while I was getting my Coke seat wrote, so our fellow students might be online there, but that's all right. This is the last part that wraps up subsidiaries, probably the least important part, because it's all about me. So this class isn't about me, this class is about you, but I mentioned this part here about me, so forgive my lack of humility. The reason I go on and on about subsidiarity is, although I'm not a law professor, I'm an attorney, and I'm proud to be an attorney. That first and foremost is why I went to law school, to become an attorney, not to become a professor. Maybe it's the same for you. So I love being an attorney, but I guess there's a little wannabe professor somewhere deep inside me, because I've always enjoyed writing. And if there is an underlying theme to all my writing, then that would be subsidiarity. I tend to focus on that issue, but never to neglect two other issues. And that's also within our Catholic social justice teaching, solidarity and human dignity. And I find solidarity and human dignity to be right there in John Paul II's definition of subsidiarity. He says here that should not interfere with the internal life of the community, should support it always with a view to the common good. You see how the view of the common good is right there as St. John Paul II defines subsidiarity. And that reflects that accurate understanding of Catholic social justice teaching that puts subsidiarity on equal footing with solidarity and human dignity. Because it is that human dignity that is of the utmost importance. We always have to respect the dignity of the human, from the moment of conception to the moment of passing from life to natural death. We have to respect human dignity in all forms. It doesn't matter if the human is disabled. It doesn't matter if they're differently abled. It doesn't matter what race, sex, religion, color, national ancestry, creed, beliefs they might have. We've always got to respect human dignity. And that, I believe, is right there in the definition of subsidiarity. But it's subsidiarity that inspired my writings. It was back in law school when I first wrote this piece. I went to law school from 1993 to 1996. For some of you, that was an eternity ago. And in 1996, I wrote this piece called Beyond Healthcare Reform, because in 1996, we had solved the issue of healthcare reform. From 1996 to the present, it still gets cited on a regular basis, and I think that's because we still haven't gotten past, we still haven't gotten beyond healthcare reform. Are we beyond healthcare reform yet? Certainly not. But that particular piece, Beyond Healthcare Reform, talked about certificates of need, which was local control over hospitals and healthcare centers. So that interested me even back then. And I had an opportunity early on to write this book. God, you shouldn't read it. No one should read it. It's looks like that. And I'll just pass it around because I'm big enough to do that. There you go. But as you pass it around, you'll see that my first book was about Florida's workers' compensation law. Because subsidiarity says that problems can be solved at the lowest organizational level consistent with its welfare. And when it comes to folks who have been disabled by industry, we can effectively, if we make our workers' compensation system work right, we can put the burden upon that industry that caused the disability, and yet at the same time, still be fair to both the injured worker and to the employer. That's what I tried to do in my book, Florida Workers' Compensation, spell out how to practice in such a way. That led me to my next book, Florida Insurance Law, which branched out from workers' compensation and went to other types of insurance. As I mentioned earlier, federal law contains reverse preemption and says that state law preempts federal law when it comes to most forms of insurance. And an actuarially sound insurance industry can serve as part of the social safety net that our brothers and sisters who are injured or suffer a calamity or a disability can need. So that's why I wrote in part of that book. My bestseller, she makes me the most money, so I love her, Florida Elements of Action. And here I try to identify, clarify, and classify all the statutory and common law causes of action in the state of Florida. Haven't gotten there yet, up to 98 causes of action. There's certainly a lot more causes of action than that. Been updating that book once a year, every year for about 14 years. Perhaps before I die, I'll finally achieve the goal of identifying, clarifying, classifying every cause of action. But without that, if we simply rely upon the common law, then we find ourselves victims. We find ourselves hurt. We find ourselves disadvantaged by judicial activism. If we don't come together as a society through our elected officials and determine what is a cause of action and what the elements of that cause of action are, then judicial activism comes into play. Judges take the roles of legislatures, which is bad in my opinion, and usurp those rights from where they need to be. And then ultimately that led me to this crazy topic that you're here on now, subnational constitutional law. I remember when a publisher came to me and wanted me to write a book about Florida constitutional law. First thing I had to do was try to find out who was practicing such a thing. I first wrote Florida Municipal Law and Practice back in 2012, I think was the first edition. Like the others, I update that one every year. And I couldn't find a group. Usually there's a bar, there's the workers' compensation bar, there's the insurance law bar, there's the federal bar, there's the appellate practice bar, there's the criminal defense bar. I couldn't find a Florida constitutional law bar. I tried to find anyone who was advertising themselves as practicing Florida constitutional law. I couldn't find anyone. To this day, I still haven't met. Have you met someone? Oh, hi, I'm a Florida constitutional lawyer. I practice Florida constitutional. Have you met anyone? Either have I. So I met the publisher's requirements, but I called it Florida Municipal Law and Practice because I did find folks who were on payroll of various state and local governments. So I called it municipal law. But as I started to teach from that class, as I mentioned earlier, there's a wonderful casebook out there. It's the only casebook out there, but it hasn't been updated since 2013. So that's when I started to write my own books. And this was an earlier edition of what we'll be studying from in our class today. And I try to, when I pretend to be a professor, occasionally I'll write a law review still. And this one came out just a few months ago. This one talks about access to courts under state constitutions. It talks about various states. There's 23 of them that have an access to courts clause in their constitutions. And attempts to offer some guidance there. So I try to write upon the topic of subsidiarity, but I don't see subsidiarity as contradicting those other premises of Catholic social justice teaching when it comes to solidarity, when it comes to human dignity, because of the highlighted terms you see there. It says that a community of higher order shouldn't interfere with the eternal life of the community. We're not saying that there can't be some regulation of the eternal life of a community. We can't say that it's completely hands-off, that federal can never have any effect or any regulatory effect. We're just saying that they shouldn't interfere with the internal life of the community by depriving it of its functions, but instead should support it and help coordinate its activities. For example, on the state level, if there's a small storm, then certainly the county should be in charge of repairing the damage. But what if it's a major hurricane? What if there's a plethora of counties that have been damaged? What if the damage is just too great for that group of counties to help? Well, then of course FEMA should come to the rescue. Of course, the federal government should supplement the efforts, should support and help coordinate the activity of the lower governments, because to do so is with a view toward the common good. So that's how I see subsidiarity. But the cliffhanger I left you with was, how does the good old US of A apply and implement these concepts of subsidiarity? I used as our hypothetical the nation of Canada earlier. In Canada, they don't have states, they have provinces, right? Those provinces don't have separate freestanding documents that serve as provincial constitutions. Instead, there are clauses within the national constitution, the federal constitution of Canada, which apply simply to that province. So if you consider those to be constitutions, what they are in Canada are simply subsets of the federal national constitution. That's not how we do it here in the good old USA. What about over in Europe? You've heard of the EU, European Union, correct? Those various nations in Europe have gotten together and they've ceded some of their national sovereignty to the European Union. Is that good? Is that bad? Well, folks that advance the cause of Brexit would probably argue that the bad outweighed the good when it came to the EU, the European Union. Whereas those who were opposed to Brexit and those who are staying in the EU would probably argue the opposite, that it was good to secede some of that national sovereignty. But that's not how we do it here. Florida isn't the United Kingdom. Florida isn't France. Florida isn't Spain. Florida isn't Greece. Florida isn't a national sovereign that has joined a union like the EU. So how do we do it here? And the answer there has to do with the topic. Yes?
Sorry to interrupt.
No, please.
The roll, the sign-in sheet, the roster.
Yeah, you want to be on attendance, huh?
Please.
Thank you for reminding me getting that. All right, here's the attendance sheet. If you are here, you should sign to indicate that you are. If you're not here, then you should not sign.
They won't sign, they're not here.
Thank you. Yeah, it's trying to make people laugh.
You know what I mean? I'm a weak.
Thank you. I am too, thanks to the Coke Zero, the caffeine ups. But I always take attendance. I mentioned this to a few folks. I'll mention it out so everybody hears it. I always take attendance after the prayer. So if you prefer not to join us for prayer, I start every class with a prayer. And show up a few minutes late, you'll be fine. You'll still get to sign the attendance sheet. The prayer is not a required part, and NOT not a required part of the class. But I hope you'll join us. Like Mikey Starks, my buddy who traveled through France, never tasted the escargot, the coq au vin, the crepe Suzette. I feel he may have missed out on taking a taste of French culture. Likewise, you may be missing out if you skip my prayer, or you may be making a wise decision. Hey, it's up to you. But I don't take attendance for that part of the class. So that answer for subsidiarity that we have in our federal system is one of federalism. We talked about the federal constitution and its, I'm going to find that slide, and its supremacy clause. And I found the slide. And as you can see on the big board, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made of which shall be made. These things shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. What exactly does that mean in practice? Let's break it down. Let's literally keep score. Let me ask you, in a hypothetical battle, who wins? The text of the federal Constitution says one thing. The text of the state constitution says another. The text of the federal constitution and the state constitution directly conflict. There is no way to reconcile the two. We've either got to obey one and disobey the other, or obey one and disobey the other. So my question to you in such a situation, very simplified situation, which one prevails? Federal or state? You say federal,
For the majority of the time.
okay? Well, what about this? What if the state constitution clearly says, despite the federal constitution, Floridians will do this? Which prevails?
I would still say the federal.
You would still go with the federal.
Yeah.
So we've got an in-your-face conflict, the state constitution directly conflicting with the federal. You see if I can make that in-your-face conflict a little bit harder. We're not before a federal judge. We're before a state judge in state court. So we're not in the United States District Court. Instead, we're in Orange County Court, Orange County, Florida. And there's a direct and irreconcilable conflict between our state and our federal constitution. But we've got a state court and a state law judge. Which prevails?
Is the, what's in conflict
Stand
giving,
firm now, stand firm.
huh?
Stand firm.
I'd say federal unless you're giving
You
more
still
rights.
say federal.
Unless it's more rights for the students.
Who agrees? Who would still say federal wins in this conflict between federal constitution and state constitution? Raise your hand if you'd like to be correct. Who says yes, federal prevails? All right, in that conflict, federal prevails. And it prevails even if the state constitution knows it's a conflict, it directly addresses the conflict within the language of the state constitution, federal still prevails. Federal still prevails even if you happen to be in a state court instead of a federal court, in front of a state judge instead of a federal judge. Federal still prevails when the plain text of the federal constitution contradicts the plain text of the state constitution. And why is that? Because of what you see on the big board here. Because of the supremacy clause. Now I know what you're thinking, that's not the only clause in our constitution, McKinley. I took federal constitution along McKinley. I know that there's amendments to the federal constitution, McKinley. I know about the 10th Amendment, McKinley, which you got on the big board right now. The power is not delegated to the United States by the federal constitution, nor prohibited to the states, are reserved to the states respectively, or to the people. Sounds like beautifully powerful states' rights language, right? That should mean, if I put it in my state constitution, that my state constitution prevails? Is that what it means? Is that what it, no, it's not what it means. As we read that 10th Amendment together with the Supremacy Clause, we cannot ignore the language that says federal preempts, trumps, is supreme, and prevails over state laws, including state constitutions. So don't be fooled to think otherwise. What this literally means is that the language of a state constitution can be unconstitutional. The language of a state constitution can be unconstitutional. How can a constitution be unconstitutional? Because of the Federal Supremacy Clause. It says federal law is supreme, notwithstanding anything, laws, or constitution of any state. Another takeaway. When I look at the text of the federal constitution, I can have some assurance that what I see written in the federal constitution is good law, right? I can't have the same assurance when I look at the text of the state constitution, because the language in the state constitution could be unconstitutional, or even could be preempted. So on the scoreboard, Fed 1, State 0. Let's continue to play the game, shall we? Again, we've got a direct conflict with our state constitution. It can't be reconciled. It's clear we've got to either follow one or the other. But the conflict is between the plain language of our state's constitution, the state constitution being the highest form of expression of state law. Our state constitution says one thing. The text of the federal constitution is silent, does not even address the topic. However, the United States Supreme Court, you've heard of this court. The United States Supreme Court has issued an opinion. And the holding in that opinion directly conflicts with the language of our state constitution. There's no way around it. We've either got to obey one or obey the other. We can't reconcile the two. So now we've got the highest form of expression of state law. The state's constitution says so. So we can't get any higher in state law. But we've gone at least one notch lower in federal law, haven't we? It's not written in the text of the federal constitution. The federal constitution is silent. It's an opinion of the Supreme Court of the United States. Which one prevails? Yes, what do you say? You say federal. You say the scoreboard should be 2-0. You say the Supreme Court of the United States, SCOTUS, if you will, and its opinion prevails over the state constitution. Who will raise their hand and agree? Who would like to be correct and agree? Yes, that is the correct answer. The scoreboard now is 2-0. Look at the text of the Supremacy Clause. It doesn't talk about a ruling from the Supreme Court of the United States. But we know that such rulings are as binding as the text of the federal constitution. And how do we know that? Well, as a law student, you know that from your personal experience. You took federal constitutional law, right? And when you went to class, all you had to bring with you was 18 pages, right? Because that's all it took to study federal constitutional law. You just needed the plain text of the federal constitution, right? And that was your entire semester, right? You just kind of read those 18 pages and figured out what they meant, right? Isn't that how you study federal constitutional law? No! You had a book that was 10 times as thick as the book in this class. And despite being 800, 900 pages, none of those pages were the text of the federal constitution, were they? I dare say in most of your classes, you never even opened the text of the federal constitution, did you? You spent the entire semester reading what? Opinions of the Supreme Court of the United States, telling you what they said the Constitution meant. And then a later opinion telling you what the former opinion meant. And then an even later opinion that distinguished the former opinion that talked about the earlier opinion. And then an even newer opinion that was a certain part of the facts that gave you a surprising outcome from the prior opinion that had distinguished the earlier opinion that talked about the prior. The whole class was based upon SCOTUS case law, was it not? In practice, what is the supreme law of the land? Is it just the text of the Constitution? Supreme Court opinions prevail, do they not? Who's got a computer? Who can visit our class website, flaconstitution.com. flaconstitution.com. I hope it's a helpful website to you. I do my best to keep it up to date. You see some slides behind me. This week's slides aren't too wordy or substantive. Other weeks will be extremely wordy and substantive. Within 48 hours of every lecture, I will have those slides available to you in PDF form right there. Also got a little laptop over here. Hello, little laptop. Recording my lecture to YouTube. So if you didn't get enough staring at me yet, you can go home and you can watch me on your television or your laptop or your cell phone or your iPhone or wherever you like to watch YouTube. And you can watch this lecture again. Links to that YouTube video will appear on flaconstitution.com. I gave a midterm last semester. You can go over to the tab that says last semester instead of this semester. You can see all my slides from there. You can see the midterm I gave. You can see the answer key to the midterm. I'm here to help, I'm here to serve, whatever I can do to make the study of Florida constitutional law better, easier, more successful for you, I'm gonna do it. And that website is part of it. But on that website, if you go to flaconstitution.com, on the home page, I've got a link to Florida's Constitution. Click on that, and it'll launch in another browser window. And you'll see the current text of Florida's Constitution right here, right now, today, up to date. And you'll see Article 1 is the Declaration of Rights. By analogy, it looks a lot like the first 10 amendments to the federal Constitution. It talks about freedom of speech, freedom of religion, freedom of the press, freedom to assemble, many other rights. Some included in the federal, others in addition to the federal. But it's there, the text of our Constitution. It's not an amendment to it. And it's first and foremost, when we created this new Constitution in 1968, we made that Article 1, we made that the lead. We started with the Declaration of Rights. Scroll down to the very last right there. I believe it's on 23 verse 26. What's the last right? It's 23. Try to block it out of my head. To paraphrase this is something along the lines of marriage is the union between one man and one woman, and no other type of union will be recognized in the state of Florida. Mckinley, is your link out of date? Is this a constitution from some foreign land? Is this Florida's Constitution you've linked to, McKinley? Is this an out-of-date copy? Clearly, this isn't today's Constitution. It is today's Constitution. It is not an out-of-date link. What you're reading there is the text of your state that you're sitting in right now. Its highest expression of its law, its state constitution. It's exactly how it reads today. Is there anything in the text of the federal Constitution that contradicts the state constitution's language that exists today that says marriage is a union between one man and one woman, and the state of Florida will not recognize any other type of union? No, there's nothing in the text of the federal Constitution to the contrary. But there certainly is a decision of the Supreme Court of the United States that says the contrary. So what does that mean? Does that mean here in Florida that same-sex couples can't marry because our Constitution says they can't? No, what it means is that line, that subsection of Article 1 of Florida's Constitution is unconstitutional. It conflicts with the holding of SCOTUS, the Supreme Court of the United States, and therefore that line is not enforceable. And it's not enforceable anywhere. It's not enforceable outside of Florida, it's not enforceable inside of Florida. Inside of Florida, it's not enforceable in the federal court, it's not enforceable in the state court, it's not enforceable in the state agency, it's not enforceable in the state courthouse, it's not enforceable. Because, you know, federal prevails over state even when the power of the federal is one notch below just the plain language of the state constitution. Let's lower the federal even another notch. Again, we have in our hypothetical, round 3, who will get the point? Our hypothetical says that the state constitution, the highest expression of state law, says something that is in direct conflict with the U.S. Code, with a law passed by the United States Congress, right there in USC, U.S. Code. Congress made this a law. They made this law, but it's not the result of the Supreme Court of the United States opinion. SCOTUS has never ruled on this. And they've made this law even though it does not appear in the plain text of the federal Constitution. So that is the ranking, if you will. That is the weight, if you will. That is the federal law where it stands in the pecking order of federal laws. It's part of the USC, United States Code. And it directly conflicts with the state constitution. Which one prevails? Which one? Who will dare to answer? You may have been scratching, you may have raised your hand, couldn't tell which. No. There's a universal symbol for when you don't want to be called on. You look anywhere but at me. You look down, you look up in the sky, you do one of these. Twiddle with a book. Yes. Wow, everyone is now doing that. Maybe some of the advice I give I shouldn't have. Oh, my hand is up. You've saved me. Thank you. So you're saying that the federal is going to prevail?
No, you said the state.
I heard well. He said the federal is going to prevail. And who is going to raise their hand and agree that the federal is going to prevail? That's right. That's right, the score is now 3-0. How did federal win that one? It wasn't in the text of the Constitution. SCOTUS has never spoken a word on it. And over here, the contradictory language was in the highest expression of state federal law, was in the state constitution. How did the state lose that battle? Check it out. The Constitution and the laws of the United States, which shall be made in pursuit thereof. Assuming the US Code itself wasn't unconstitutional under the federal Constitution, assuming the federal Constitution didn't make that congressional law unconstitutional, then that's a law of the United States that was made pursuant to the Constitution, because under the federal Constitution, who makes federal law? Congress, yeah. The current federal administrative state, we might even argue others do too, huh? But certainly Congress does. So who won that one? Federal.
Seems like the Fed's winning, like,
You're seeing a trend.
like, I've noticed.
They've got momentum here.
Like,
Let's knock the federal down a notch and see what happens.
So are you saying that the next one, the state's gonna win?
I don't know. Let's find out. Battle number 4. Again, when it comes to the state law, it's the highest expression of state law. It is enshrined in the plain text of the state constitution. But that plain text of the state constitution, like all the prior hypotheticals, is in direct, irreconcilable conflict with a federal law. But this federal law, hypothetical number 4, is not the text of the federal constitution. This federal law, hypothetical number 4, is not the result of the Supreme Court of the United States ruling. They've been silent on it. This federal law, hypothetical number 4, was not passed by the United States Congress. This was an act of a federal agency. Let me make it more interesting. It's a despised federal agency. This federal agency is a low-budget federal agency. It's not even high on the federal agency pecking order. It struggles to make ends meet. Indeed, the head of this federal agency was not elected by anyone. It's an appointee. Federal agency has an appointee. So now, in the CFR, the Code of Federal Regulations, we find this despised federal agency with its appointee as its head and its budget struggles has promulgated a federal code of federal regulations, and that regulation is in direct conflict with the highest expression of state law in its state constitution. Ladies and gentlemen, which prevails? Which wins hypothetical 4? Where do I put the score? Come on now, tell me where to put it. Over here by the Fed? Or over here by the state? Over here by the Fed? Or over here by the state?
Put it in the middle.
The answer is the Fed. Fed wins again, the score is 4-0.
So why are we taking the state constitution?
Thank you,
Can you just explain that to me?
thank you. How about I try and make it worse?
No.
It's not in the text of the federal constitution, hypothetical number 5. SCOTUS has never ruled on it. The United States Congress has never passed the law. Not even a despised low-budget federal agency has promulgated a rule on it. But one of the 11 United States Circuit Courts has ruled. They ruled on this out of the 11th Circuit over there in Atlanta, which, as you know, covers where you're standing here, covers the state of Florida. And the other circuits have not ruled yet. And the ruling of the United States Circuit Court of the 11th Circuit, which includes Florida, directly contradicts the Florida Constitution, which prevails. We're up at score. Fed wins. Let's drop it down a notch. Hypothetical number 6. Federal Constitution is silent. United States Code is silent. Congress has never ruled. United States Supreme Court is silent. They've never ruled on this. Code of Federal Regulations, there's nothing. No federal agency has ruled on it. It's never come before any United States Circuit Court. But there's a trial court. Turns out there's 3 of them here in Florida. We've got the United States District Court for the Northern District of Florida. We have the United States District Court for the Middle District. and we have the United States District Court for the Southern District. All three haven't ruled, but one of them has, just the Middle District. And its ruling is irreconcilably in conflict with the plain language of Florida's Constitution, which, of course, Florida's Constitution's plain language is the highest expression of state law. Which one prevails?
Federal.
Which one?
Federal.
Fed wins again.
The Fed always wins.
Fed wins again. But I loved your question best of all.
I know,
Why are we here?
exactly.
Why are we here? Yeah.
For anything that doesn't contradict.
I'm in a room with 5 professors from this university, and they asked me, don't you agree that this should be a required class? And I've been teaching since 2015. They're expecting me to say yes. I said no. Why are we here?
Because the Fed destroys all beta. No, but seriously, why are we studying
Why are
if the Fed always wins?
Federal Supremacy Clause is appropriately named and described as
The supremacy
a
clause.
supremacy clause. It is important to note that federal law wins. So when can these concepts of subsidiarity come into play in United States federalism? When can questions devolve? When can there be a devolution of problem-solving power? When can local problems have local solutions? What is required? There's 2 hands up. I think maybe yours was first.
Is it a rhetorical question? Do you want me to actually answer?
I'm hoping we get more than just questions today. Let's see if we can get some answers. Do you have an answer?
Yeah, it's whenever the state grants more rights than what the federal constitution is giving.
I like that hypothesis. I like that hypothesis. I don't disagree that under that concept of a laboratory democracy, that a state can grant greater rights than under the federal. But I ask you this, how? How? When is the state supreme? When does it have the authority under United States federalism to do that? How? Your hand was up also.
When the federal government allows it.
Whoa.
Because we've got
Anybody got one of those bells that goes ding, 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 ding? We just got a jackpot answer. Please repeat that loud and clear.
When the federal government allows state governments.
When the federal government allows it. Somebody repeat after me. When the federal government allows it. Let me hear it.
when the federal government allows it.
When the federal government allows it. One more time. Some of you I cannot hear. What's the answer?
When the federal government allows it.
One more time for posterity. There's people in the next room who can't hear us.
When the federal government allows it.
Thank you. Thank you. If you're going to have an independent state constitutional law jurisprudence, you're going to need authority from what source?
The federal government.
The federal government. If you're going to have a devolution, if problem-solving authority is to devolve to the state and then to the local level, where must we find permission and authority to do so? In federal law. Because of the supremacy clause. Federal law must authorize it to happen. We talked about the instance of state insurance, and we talked about reverse preemption. Federal law said that state law is supreme over federal law when it came to those particular types of insurance. That's why states had adequate authority to regulate their own insurance law, because the federal government empowered it to do so. This is the answer of federalism. But McKinley, you forgot the 10th Amendment, McKinley. Come on, McKinley. The 10th Amendment says the powers not delegated to the United States by the federal constitution or prohibited to the states are reserved to the states respectively or to the people. There was a slight gap in time where all those who made this argument, this 10th Amendment argument, didn't win before SCOTUS. It's just a brief period of time. 71 years. For 71 years, everybody who made that argument to SCOTUS lost. 71 years. That's more than a lifetime. For most, that's more than a generation. 71 years. Yes, there is a 10th Amendment. But in practice, it is the supremacy clause that is the issue. Even in those instances where you might be able to successfully argue that the 10th Amendment allowed it, federalism allows federal supremacy to rear its head and quash states and state powers whenever that federal law is duly promulgated. It does not take an amendment to the text of the federal Constitution. It does not take a ruling of the Supreme Court of the United States. It might not even take a decision to pass a law by the US Congress. There are many sources of federal law. And almost without fail, when that federal law is irreconcilably in conflict with state law, the federal prevails. So, what's the lesson? What's the takeaway? What do I write down? What do I make sure to learn in lesson 1 of this class? First and foremost, just because it appears in the text of the state constitution, that does not, N-O-T, does not mean that I can rest assured that it is the supreme law of the state. Just because it appears in the text of the state constitution does not mean I can rest assured that that is the supreme law of the state. Look at the end of Article 1, the Declaration of Rights, and its definition of marriage. Is that the supreme law of this state or any other? No, it is not. So that's takeaway number 1. Takeaway number 2, if I want to develop an independent source of state and constitutional law jurisprudence, I need to find a reliable federal authority as a basis for that state jurisprudence. Takeaway number 2, if I want to develop an independent source of state constitutional law jurisprudence, then I must find an adequate federal basis of authority for developing that independent state constitutional law jurisprudence. For example, in your federal common law class, I dare say, you never went to class with a copy of the federal Constitution, and instead you looked around hundreds and hundreds of pages of SCOTUS decisions. How can I do the same in a state common law class? I can do the same if there's an adequate federal basis for developing that particular jurisprudence. I saw a hand up, yes.
I was just gonna ask you to repeat number 2 again.
Oh, gosh, okay. Something along the lines of, come on, Holy Spirit. In order to develop an independent source of state constitutional law jurisprudence, I must find an adequate federal source allowing and empowering that particular state common law jurisprudence. I hope that's really close to what I said the first time. Okay. Who has a question about federalism? I do. The city of such and such, that's a real city. City of such and such made it up. I'm afraid I offended the Canadians earlier by thinking that they're going to war against. So I'm just going with such and such. City of such and such does not like the state of the law when it comes to immigration. So the city of such and such has declared itself to be a sanctuary city where federal immigration laws no longer apply. That's a crazy hypothetical, right? That can never happen in the real world, could it? Or does that happen every day? Work with me now. What do you know about federalism so far? Which side would you like to take? Would you like to be the mayor of the city such and such and argue how you're going to make it on the scoreboard here? Or would you rather argue the other side, that federal might prevail? Well, if you want to be on the winning side, you're probably going to want to pick the federal side of that argument, correct? Now, are there exceptions? Well, there's exceptions to every rule, such as, for example, unfunded mandates. If we ask the state or local government to do the job of the federal government and to enforce the federal law, there are opinions of the Supreme Court of the United States that say there's an obligation of the federal government to fund the federal government's job of enforcing federal laws. And you can't avoid federal government, you can't avoid your duty to pay for your own federal government law enforcement by simply passing an unfunded mandate. So I'm not saying that there aren't exceptions, but the general rule, like in our 5 hypotheticals, where there was an irreconcilable conflict between federal law versus either a state or local law, well, in that instance, you've seen the scoreboard. You know the score. You know that federal prevails because of the supremacy clause. So let me ask another question then. Is subsidiarity alive and well under our federal system? Or is it dead as a doornail? I see a hand up, yes?
It's alive, using the same example you did earlier with marijuana.
I like it. So you put forth a hypothesis, and I would join in it. In fact, I would write a book about it. That perhaps it is alive and well. And just as the gentleman to your left pointed out, there is that concept. Where'd it go? Lost it. There is that concept of a laboratory of democracy. So your hypothesis is, and if I sound like I'm criticizing it, that's disingenuous, because I'm with you. Your hypothesis is that the laboratory of democracy is alive and well despite federalism. How so? How could that be? Which will return to the question I answered your question with. How? How do I have a laboratory of democracy?
Oh, okay. Because the federal government allowed it. And
Because the federal government allowed it. I have to have that as part of the answer. That's right. The federal government allowed it. Join me, if you will, in State versus Horowitz. Therein, my friends, lies the answer. State versus Horowitz begins on page 3. Hey, we're 2 hours into the lecture and I'm on page 3. We're making good progress, huh? We'll blow through this text for the end of the year. Okay, so we're on page 3. State versus Horowitz. What's going on here? There's been an arrest. There was a pre-Miranda statement or silence by the accused. And there's an acknowledgement in State versus Horowitz, a 2016 decision of the Supreme Court of the State of Florida, found at 191, 7th, 3rd, 429, an acknowledgement by the Supreme Court of the State of Florida that the federal Constitution does not protect the accused, Ms. Horowitz. The issue before the court is whether that Declaration of Rights, that Article 1 that you looked at in our state constitution, whether Article 1, Section 9 precludes the state from using the defendant's pre-arrest, pre-Miranda silence as substantive evidence of guilt when the defendant does not testify at trial. The opinion holds that under the federal Constitution, that there wouldn't be such protection. But then the opinion holds that under the state constitution, there is such protection. How? How did we get there? How did we grant greater rights under the state constitution that didn't exist under the federal? And here, ladies and gentlemen, is the answer. It's right there in State versus Horowitz and so many other opinions. The answer is that the federal serves as a bare minimum. The federal is the floor. No state can grant any of its citizens anything less than a full panoply of federal rights. And when I say the full panoply, remember the scoreboard, 6-0. The scoreboard didn't just talk about the plain text of the federal constitution, did it? No. It explored various sources of federal law. And indeed, our rights as Americans derive from many sources in addition to the plain text of the federal constitution. You have a right, freedom of religion. That's in an amendment to the plain text of the federal constitution. You have a right to have your insurance company cover a pre-existing condition. Where's that? That's in the United States Code, right? Your rights might come from any of the things we talked about in hypotheticals 1 through 6. The full panoply of federal rights constitute the floor. Remember what happened when any state law, even the state's highest expression of this law, the state constitution, attempted to contradict even the lowest level of federal rights? What happened? Federal prevailed. That's why you're correct. Federal is the floor. I think I'm quite svelte. Others say that I'm heavy. Hypothetically, let's call me the fat man. To help you remember, here's a fat man standing on top of a cement floor. And no matter how hard the fat man jumps on the cement floor, the fat man does not sink below the floor. That self-deprecating audiovisual, hopefully, helps you remember that we can't, in our state constitution, sink anywhere below the floor. We cannot grant our state citizens anything less than the full panoply of federal rights, regardless of their federal source. So long as state law has done so, then states can grant even greater rights to their citizens. This is the concept we describe as a laboratory democracy. How can that happen? It can only happen if there is an adequate and independent basis for that state law. The test comes from a Supreme Court of the United States decision called Michigan versus Long. Why do I turn to a federal decision to justify what a state can do? Because of the supremacy clause. I need an adequate state basis. Michigan versus Long says that the Supreme Court of the United States lacks the power of review. Not that they shouldn't review, not that they ought not to review, not that they probably can't review, but that they lack jurisdiction. SCOTUS, the Supreme Court of the United States, can't take jurisdiction over an opinion of a state court that has both an adequate and an independent state law basis. When is the state law basis adequate? That was the jumping, folks. Whenever that state law does not deny any of the full panoply of federal rights, then it is adequate. When is it independent? When its source is a state law source. How does that work? Say the Supreme Court of the state of Florida were to rule that a particular marriage is null and void because Article 1 of the Declaration of Rights of Florida's Constitution says that marriage is solely between one man and one woman. Is that an enforceable decision of a Florida court? Or is that an unconstitutional action of the state government? It's the latter. It's an unconstitutional action of the state government. And how do we know that? Because it lacks an adequate basis. It denied one of the full, or part of the full panoply of state rights that are enjoyed by every American because it's part of the federal full panoply of rights. What if, in a different hypothetical, in a different case, the Florida Supreme Court reinterprets the federal Constitution to grant greater rights to Floridians? Again, unconstitutional, an unconstitutional act of state government, but for a different reason. There, it wasn't independent. The state court was attempting to reach its own and different opinion as to what federal law meant. The state's high court is not the ultimate arbiter of federal law and federal rights. It is the federal system, and ultimately, the Supreme Court of the United States within the federal system, that is the ultimate arbiter of federal rights. No state can take it upon itself to create new rights in a laboratory of democracy by reference to federal law or to the federal Constitution. It can only do so by reference to state law or the state constitution. You might call that the ceiling. If we're going to call the full panoply of federal constitutional rights the floor, then perhaps we might call that the ceiling. So the adequate part would be the floor, the independent part would be the ceiling. And we can see those words used here in the opinion. I quote from State versus Horowitz. Put simply, the United States Constitution generally sets the floor, not the ceiling, of personal rights and freedoms that must be afforded to a defendant by Florida law. As we explained in another opinion, Kelly, we have the duty to independently examine and determine questions of state law, so long as we do not run afoul of federal. See how it works? So let me return to an earlier question. Why are we here? Remember me talking to those 5 professors, telling them, well, this class shouldn't be required? I tried, folks, I tried. Part of the argument as to why you might not require such a class is the fleeting nature of state constitutional law. Whenever federalism decides, it erases that state common law jurisprudence. But in defense of studying this topic, state constitutions, just like the federal, can be a font of civil rights and independent liberties. State constitutions, just like the federal, can be a source of human rights and dignities. State constitutions, just like the federal, can enlighten, strengthen, and empower. State constitutions, just like the federal, can advance Catholic social justice teachings such as subsidiarity. State constitutions, just like the federal, can empower you to bring justice. State constitutions, just like the federal, can be an arrow in your quiver in the fight against injustice. From that perspective, none of us have wasted our time taking this class today. And with that in mind, in our next class, we will begin to study one of the laboratory of democracy results where Floridians have greater rights than Americans as a whole. As you begin to study Chapter 2, which we won't finish in one class, but we'll get a good chunk of it done, you will see how government transparency, government accountability, government sunshine laws, if you will, give Floridians no less than the full panoply of federal rights but grant Floridians even greater rights to government transparency and accountability than Americans have as a whole. And you'll see how that happens as we study chapter 2. Until I see you next week, may God bless each and every one of you. Looking forward to a great semester, and hopefully I will not fail you, and I'll serve you well. Thank you.
Definitely don't fail.
Now, I did say hope.